So now I'm going to pull up the document here. So this is an actual filing in Minnesota state courts challenging the custody statute from a constitutional basis. So I'll give it to I'll let you take it away here, Ryan.
Yeah, so I don't want to bore people, but one interesting thing, and maybe we can stop after this, but one thing to note, right, is this subject line right here of the argument. Parenting time is a fundamental right. That's the point, right? That's the point that we're trying to tell the courts. Like, hello, I have to have 50% parenting time unless you can prove that I'm literally endangering my child. And if I was endangering my child, then I would be liable to criminal law for child abuse, right? So unless there's a criminal action pending, this is an aggressive argument. You should have 50-50 parenting time, like, unless there's a finding of endangerment. So check this out. The question is, and the judge will say, do you have authority for that statement? Do you have authority for the statement that parenting is a fundamental right? Well, guys, here's a long list of cases, right? The beginning of this paragraph, the beginning of my brief, states that the Supreme Court has long asserted that the parents' rights to their kids is fundamental. Look at all these cases. Meyer versus Nebraska, 1923. 1923, right? This is almost 100 years ago. Pierce versus Society of Sisters, 1925. In 1920s, we acknowledged that one of the things that we hold most dear to this country, and what's so baffling is that the family courts seem to have forgot this. The family court judges, when they take their oath and they sit up there, they uphold the Constitution of the United States, seem to have forgotten the case law outlining what exactly that means. May v. Anderson, it's all the same thing, guys. Griswold versus Connecticut, Prince versus Massachusetts, all the way down to Troxel. And the Troxel is the case that Mark and I were talking about in the beginning. It's the beautiful quote that says, basically, judges don't get to step into the shoes of parents. And that's what so many folks on forums and chat rooms and Facebook pages, are saying, is that the court just trampled me. They've isolated me. They've trampled me. And, as we're looking through this document here, this case law isn't new. It's not new. It's not novel. It's a long asserted Supreme Court history, over 100 years in the making. And I think that's really important to highlight. And it gets at it right in this first page and a half. This is not new. This is Supreme Court precedent. It's not doctrine. It's as they say here, the basic civil rights of man, right? So, we're back. Cool. I think that's important to emphasize. Not only, Judge, I have a fundamental right here, but it's a long-standing fundamental right. And guys, Mark, we should figure out a way to get this as a PDF somewhere. I don't know how we can do that. Maybe we can host it as a link.
Yeah, I'm seeing all the comments from everybody. I have a copy of it. I will, what I'll do is I'll work and get everything, all the names and everything redacted from that, or I guess I'll take off that first page and just
the meat of it.
Yeah, just take the actual arguments of it, and we can post this as a resource on the Father's Rights Movement page.
Yeah, I think that'd be great. Because people are often wondering, right? Like, okay, I know I have a constitutional right, but what does that mean? What do I do? What motion do I make? What tactic do I specifically use? And I think the thing is, you have to educate the court, right? And you have to have your attorney or attorneys have the gumption, the cojones, whatever you want to say, to make that move. And it's not that big of an investment, because all you need to do is copy paste right here. In every single state, including the District of Columbia, this case law is good. And this case law trumps state case law. This is the United States Supreme Court talking right here. And so I think in family court, the system is broken. It's like trying to play by the rules of family court will fail, right? If you're just trying to do the same old, it will fail. It will fail. It has failed. So the answer has to be creativity. The card that's not being played right now is the Constitution, as far as I'm concerned. So that's why I'm interested. And this, what we just talked about for the last half hour, is parenting time. We have yet to talk about alimony or spousal maintenance, whatever your state calls it. But there are constitutional challenges to that, as well as child support. But suffice it to say, this is what most people focus on is parenting time.